action. We're at video 8. Holy mackerel, we're moving right along here. We got a long way to go. Short time to get there. Where am I? Okay. No, I don't have a voice, and don't call me up to join your rock and roll band. Okay. All right. So now we know that very first moment I said the monarchy's Lord Chancellor, the bishop, was granted the task to establish courts to hear matters that arose from the administration of these new equitable, aka beneficial interests. And there now we understand what the beneficial interest now. It is not seen in common law because it's not the common law. It's a different subject matter, and that's a point to make right here. Subject matter and status create jurisdiction. Subject matter status create jurisdiction, and based on your status then affords the remedies based on the subject matter you hold. And we're constantly commingling subject matter, and we're not going to get into that point right now. We're going to arrive there somewhere along the line, but we're going to continue on with the Lord Chancellor, who was a bishop, was the ear of the, or the voice of the conscience of the king. That's a better way of saying it. The Curia Regis was a settlement of a group of barons that evolved into Parliament we have today, that were the laws in helping the king manage his affairs and the manners and manage their lords. That was a like the Round Table group, and the church was upon itself because it had its own god and had only had a right to use the land. And then we had the lords now who wanted to control some land interests, could never do so in a common law, nor where they could ever get out of the rights of the service and rights of the debts they owed and all that kind of stuff. So they now began to transfer the legal title. They don't have it anymore. We have to get that through in the mind. Once you transfer that duty and power onto someone else, you do not have it. And this is going to be a valid point for you to continue to think about, that once you transfer something, you don't have it. It's like when you transfer that car over to another, you do not have it. Okay? You're transferring all that powers and duties that you had within that to another. Okay? You have a right to go get another car, but you don't have a right over that car that you just transferred. Well, the same thing within when you transfer over to trustees, you don't have legal title anymore. You have no interest into it. And those settlers came as a beneficiary as a subsequent practice of no longer having legal title and only wanted to use only a right to the use of that land and receive the beneficial value of that land, to which then these lords created titles. And that created problems because no one knew who held what, and when an entail might show up and say, I'm going to try to destroy your rights because you don't know what you're going to get into with this new inheritance to the firstborn son, what type of person that was, inasmuch as you don't know what he's going to try to do within the dynamics of those settlements of those interests in equity. But most importantly, you didn't know as a new beneficiary, as a immediate beneficiary under the trust that you created with these fiofis, if these fiofis will even honor the agreement you made, because guess what? This is where you shoot your own self in the foot. You couldn't go to the common law if those, because you gave that legal title over to these trustees, these fiofers. It's called a fiofment. Fiofment is that transfer of that interest you had into fiofers, and those fiofers held that legal title. And how do you know they were going to honor that? Now you didn't have any right in common law because you didn't have the legal title to possess and come to the king with your grievances. So then the Lord Chancellor became the conscience of the king to settle those problems that arose from the beneficiaries not getting their just rights. How would I say it? The just rights adhered to because the fiofers weren't performing according to what that agreement was in the first place. And there you go. There's that agreement, the right of something, the beneficial right to something. That's where equity came in, and the laws of equity, and the bishop came in to look at the agreement. That's when it became the spirit of the law. What was the spirit of the agreement? When that lord who had legal title transferred that legal title into the trustees, what was the spirit? So the bishop then looked to the agreement. He couldn't look to the common law because it had nothing to do with common law. He looked to the agreement to say, well, hey, you guys agreed to this, and now you're not performing. The beneficiary is not getting his just rights based on the agreement you made. Now, here's another thing you have to dynamic. You have to think about why was he interested to settle those matters. Because if you destroyed the trust, then you destroyed all of those titles that were subsequent based under that trust. Do you see the problem? You create a domino effect where you start destroying things. Now you're back in common law again, and everybody doesn't know what's going on. And guess what? That's where lawyers came in. Lawyers didn't deal in common law. They dealt within the use of the land. The common law was inherently done by the inns of the court, the barristers. The barristers were those who held and argued for and interpret the law and brought to the judges based on those who held a legal interest in the common law. And the corporation, the Roman Church, were only subject to the uses. And that's why there was that the fight between the uses. The lawyers would call the barristers of the inns in the court heretics because they didn't believe in the God, which is the equitable right and right to use the land. So they were classified as the heretics. And that's the establishment of the whole system, predominantly of who's creating the sin, who's going against the law, and who's going against equity. So that's what it is. It's just the system of land laws that Roman Church held to use, and the barristers in the court were the ones that argued the principle, which is the common law. Okay, I digressed a little bit, but that's a good little feature to add into it to see how that all developed. Okay, so the bishops within courts of siege went to each of these manors to hear disagreements between the new beneficiary and those he was having with the trustees of the fee offers. And there you go. They had to be the bishop to say, hey, I looked at the agreement, you're not withholding the agreement, or the beneficiary is not doing what he said he was doing, and he's now trying to deal with the legal title. And if he deals with the legal title, which he has no trust into, he'll create a disruption in the trust itself. Therefore, it dilutes the idea of the trust in its infancy. It's the principle infancy. There's another principle within itself, another agreement. He could not come in and then say, you know what, that's it, I'm ending it. Because you had to just think common sense why. And then we're going to get into reversion later on, that in the clause, the one who became the beneficiary now, which was the forelord, he had the right of aversion to say, I'm ending the trust, and I'm going back to my right that I first held, which means you're going to have to transfer that legal title back into me, which was part of the agreement for you to even hold that legal title in the first place. That now goes back and is recognized under common law, and as soon as you went back into that, you went back into the same problem you had with the common law interest and those rights held, the rights of the prerogative of the monarchy. So you see that doing one thing destroyed another thing. So each thing had to develop through the evolution to make sure everything else was protected. And that's why everything is protected. It's segregated purposely. If you're dealing in equity, you're dealing with a trust. If you're dealing with the common law, you're dealing with the tenure, what's now is called free and common soccage, but before it was a feudal land tenure that ended in 1688, that was held in the monarchy. Okay. Equity could hear matters concerning verbal contracts, matters of land law and trust. Soon equity became favorable over common law for its ease and fluidity to arrive at judgment. It was easier to deal with courts of siege and look into the agreement than deal with the common law, because the common law was strict. You couldn't discuss anything that if you brought in a moment of feeling, well, this is not fair. Okay, well, we're looking into the common law, and the common law says this. It's black and white. There's no gray area. Which equity did offered an arbitrary method in which to look at the agreement by looking at the agreement itself and saying, well, what's be based on the spirit, based on the honor of the law. We don't have to look at the black and white. We can say, well, you're sort of both right here. I can't, we've got to look at the fact that no one's receiving an adjustment over the other, that everybody's treated equally in the moment of that agreement. So how can we come at something that's going to work for both? Okay, if there's some sort of disparity, not too far of disparity where both are right, but we've got to come to some equitable agreement conclusion, and that's where the equitable point came in, where the courts, the chancellor had the right to say, well, this is when I can start saying and start creating laws that begin to overreach those things in what were mandated in common law. Because we move to the agreement now outside of the common law, but let's say you're stuck in somewhere in common law, there's something here that has to be done in common law. Well, maybe that common law would affect something in a trust, to which would then dilute that power, and then it would destroy a lot of things within the agreements. We couldn't destroy those agreements, so that's when equity started getting power based on creating injunctions and so forth that can overreach writs of common law, because the chancellor was able to now affect a power that made sense, that if you did do this in the common law, you'll destroy all the trust agreements in here, and it wouldn't work either. Okay. Again, I might have digressed, but there's so much to unpack on this. Equity established writs such as specific formants and injunctions that could overreach the power of the common law. And then after 1688, common law evolved as far as it could go, making equity the primary law of choice for courts and the people. And we'll stop there and we'll move to 9, because I got to put a log on the fire.